So the battle over the Texas border just got even more complicated after the Supreme Court issued a 6-3 order. The Fifth Circuit Court of Appeals has now issued their own order, and it halts the enforcement of Texas SB 4, which inevitably is probably going to result in a new Supreme Court review. So let's talk about what is now happening. Now, real quick before we jump into this video, I want to ask you all for a huge favor. I was looking at some of my analytics, and about 60% of all my viewers are not actually subscribed to the channel. So if you support this type of content and you want this to get out to more people, please consider subscribing to the channel, and then also just double check, because YouTube loves to unsubscribe people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, we need to talk about what is now developed after the Supreme Court issued a 6-3 order in the Texas border dispute cases. Things are getting even more hectic after that Supreme Court recent order, and that's pretty much because the Fifth Circuit Court of Appeals has issued their new own order. The Supreme Court in a 6-3 order denied the Biden administration's request to vacate a Fifth Circuit administrative stay. That 6-3 order had a lot of people making statements online that the Supreme Court had upheld SB 4 and that Texas could fully enforce SB 4. Many were claiming that this was a full enforcement of that piece of law. But a lot has changed in this legal battle since the Supreme Court issued that 6-3 order. With these cases back in the hands of the Fifth Circuit, the Fifth Circuit Court of Appeals has just taken action in this case and issued a 2-1 order of their own, denying a stay request, which in effect has blocked Texas from enforcing SB 4. So that's the current status. Texas cannot enforce SB 4 because of that recent Fifth Circuit order. Now, we need to do some background on these cases so you understand what the Supreme Court did in their order and how this case has developed after that order from the Supreme Court, and what the Fifth Circuit just did with their own order. While the Supreme Court was dealing with a different case and a different controversy about the Texas border, that one being the cutting the wire of the border, go watch some of my prior videos on that, there was another case and another legal battle developing, which is these cases here, which deal with the passing of SB 4. Texas SB 4 effectively makes it a crime for an individual to violate federal law by crossing into Texas at any location other than a lawful point of entry. SB 4 also has a different aspect of the law where it makes it essentially also illegal for a person to re-enter into the US if they've already been denied admission before or they've been prior removed. So it enhances that aspect. And finally, there's a piece of the law where a judge in the state of Texas can issue orders sending those people back to the nations where they crossed, essentially ordering them under the judicial process that they have to go back to the foreign nation where they crossed. This bill was challenged by the Biden administration, and a district court on review issued a preliminary injunction, which in effect prevented Texas from enforcing various parts of SB 4. Texas then appealed that injunction up to the Fifth Circuit Court of Appeals. Now, in response, originally the Fifth Circuit Court of Appeals issued an administrative stay on that lower court decision, which, with that administrative stay in place, Texas, in effect, could enforce SB 4. Now, in response to that administrative stay, various cases were then consolidated, and then all those cases filed for an emergency review by the Supreme Court. There was an emergency application for Supreme Court intervention that was filed with the Supreme Court. Well, last Tuesday, we received a 6-3 order from the United States Supreme Court, and it denied the Biden administration's request to vacate that Fifth Circuit administrative stay. That means that the Supreme Court decided in favor of essentially leaving in that administrative stay, leaving it in place until the Fifth Circuit either decides on a true stay order or until the case is decided at that appeal level. Now, there were some concurrences by Justice Barrett and Kavanaugh, and they state in those concurrences that if the Fifth Circuit had issued a stay pending appeal, this court would apply the 4-factor test to decide whether to vacate it. But the Fifth Circuit has not entered a stay pending appeal. Instead, in an exercise of its docket management authority, it issued a temporary administrative stay and deferred the stay motion to a merits panel, which is considering it in conjunction with Texas's challenge to the district court's injunction on SB 4. Thus, the Fifth Circuit has not yet rendered a decision on whether a stay pending appeal is warranted. That puts this case in a very unusual procedural posture, she stated. Now, she went on to also state in that concurrence that administrative stays do not typically reflect the court's consideration of the merits of the stay application. Rather, they freeze legal proceedings until the court can rule on a party's request for expedited relief. She then concluded by saying if a decision does not issue soon, the applicants may return to this court. So what she's essentially alluding to there is all the Supreme Court was doing there with that 6-3 order was telling the Biden administration that their request for intervention was a little bit too early. They essentially said, let the Fifth Circuit review the true stay order, issue a decision on the actual stay order, and then at that time, if the parties don't like that, they can go back up to the Supreme Court. Now, interestingly, a lot of commentators online were saying, well, because of that 6-3 order, Texas had completely won the case, that they could fully enforce SB 4 and that the game was over. But really, that 6-3 order really just amounts to the Supreme Court calling a false start on the Biden administration. And a lot has developed since the Supreme Court issued that Tuesday order. That same day after the Supreme Court issued that 6-3 order, the Fifth Circuit issued their own order and on their own removed their own administrative stay. So the Fifth Circuit administrative stay that was debated and went up to the Supreme Court and was issued on a 6-3 order, that whole debate that was going on, that own order was removed by the Fifth Circuit, and the Fifth Circuit did that on their own. A hearing then took place last Wednesday, I believe, on a true stay order. The Fifth Circuit heard arguments on whether or not they should grant a true stay order in favor of the state of Texas that wanted that stay, or would they leave the injunction in place and halt the enforcement of SB 4? And we have received the order from the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals has issued an order 2-1 in favor of the Biden administration. They have denied the stay that Texas wanted. So Texas currently cannot enforce SB 4 because the Fifth Circuit has ruled against them when it came to the stay request. The Fifth Circuit will keep the block on SB 4 in place at least until they decide the preliminary injunction, which is set for a hearing in just a couple weeks. However, in reality, the outcome of this case is almost predetermined. The Fifth Circuit granting the stay in favor of the Biden administration also means that the likelihood is, and the likely outcome of the case is that they will also grant a preliminary injunction in favor of the Biden administration because a lot of the factors are very similar for a stay request and then also a preliminary injunction. This fact was echoed by one of the dissenting judges who would have granted the stay in favor of the state of Texas. Judge Oldham essentially said in his dissent that today the majority denies the state's request to stay that injunction. In about a week, our same panel will consider the preliminary injunction under 28 U.S.C. section 1292A1 and presumably affirm it for substantially the same reasons given in the majority opinion above. Then the district court will presumably have a trial before entering a permanent injunction, but it's unclear what there is to try, both because of today's preemption holding and because then as now, there will be zero application of the state law to anyone. If this case comes back to us for another appeal, it will be controlled by our section 1292A1 decision under the rule of orderliness. So absent intervention by the en banc court or the Supreme Court, that will be that. Now, what the dissent here is essentially signaling is that this decision by the Fifth Circuit granting the stay in some ways closed the door on the enforcement of SB 4, because despite what happens in some of these legal proceedings going forward, at least at the Fifth Circuit level and the district court level, they're now going to be bound by what the Fifth Circuit said in granting this stay. The only possible way around this is for Texas to, once again itself, go up to Supreme Court and ask for Supreme Court intervention. But even with all of that, there is no certainty that Texas will ultimately win and get to enforce SB 4. Now, yes, Supreme Court issued a 6-3 order prior in this case to essentially not vacate an administrative stay, and that went in Texas' favor, but that doesn't mean that Supreme Court will affirmatively actually step in on behalf of Texas and grant a true stay. The Supreme Court granting a stay in favor of Texas would mean that the court would be saying, yes, Texas could enforce SB 4. And to me, that could be asking a little bit too much of the Supreme Court, especially at this early stage of the case. I don't think the Supreme Court is going to want to step in early and issue a stay in favor of Texas and allow them to issue and enforce SB 4. Now, outside of seeking en banc panel review or going to the Supreme Court on emergency application, this case will now move towards a preliminary injunction review in the Fifth Circuit. But again, the likelihood is that the Fifth Circuit here, the same panel, will issue a 2-1 order in favor of the Biden administration and grant the preliminary injunction. And now where this leaves us is we're waiting to see how Texas will respond. Are they going to seek en banc panel review? Are they going to go for an emergency application in the Supreme Court, ask for the Supreme Court to issue their own stay? Or are they just going to kind of duke this out at the appellate court level, do the preliminary injunction hearing, which is going to take place in just a couple of weeks, and then take this down to the lower court, maybe take this loss? It's going to be interesting to see how this develops. But I think in some ways, I think they will go back to the Supreme Court for an emergency application. This is one of those cases that is moving at a lightning pace. It's made its way up the Supreme Court fast. Just last week, it was in the Supreme Court. Then it went back down the Fifth Circuit. But the bottom line with all this is right now, as of the time of me making this video, Texas cannot enforce SB4. They cannot do the aspect of SB4 where they could arrest someone, try to, take them back to the courts to get a court order, to send them back to the nations they came from. They cannot take these actions under SB4. And that's the status that has happened because of that Fifth Circuit 2-1 order. So hopefully you guys found this video helpful. It's a very dynamic legal issue. A lot is changing pretty much day by day. So make sure you're staying tuned to the channel. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.